Good afternoon, everybody. I'm Fay Collinson. I'm a barrister at King's Chambers, and I'm here today to talk to you about the recent decision of Her Honour Judge Hilder in EG and AP, which was handed down last month. I hope everyone can hear me. If there are any problems, if you could just drop me a message in the chat function and I can try and address that. My contact details are here. Many of you will have them already. For those of you who have attended previous seminars, I always send out the slides afterwards, so I'll do that after. Please feel free to send them all to your colleagues also. We do also record these webinars and send out the recording to everyone. I believe they also go onto our King's YouTube channel too. So I start, someone's sending a message. Sound is all good, great, glad to hear it. So I start off with the background. It was a property and affairs case in which I was instructed initially for DG and then on appeal for EG and DG. In terms of the family background and setup, P was the mother, MMP, and she has 3 children, EG, IP, and AP. DG is MMP's son-in-law and EG's husband. The 4th respondent in the proceedings was DG and EG's daughter, SB. The dispute primarily was about lasting power of attorneys. I'm sure many of you have dealt with those types of applications. IP and AP had, MMP had granted lasting power of attorneys to IP and AP, both health and welfare and property and affairs. They sought registration of those lasting power of attorneys, and EG objected to their registration. And the basis upon which she objected was on the grounds of undue pressure and fraud, which is perhaps one of the less common bases of challenging an LPA. In my experience, usually it's on the basis of a want of capacity. But the application was also predicated on the basis that there were subsequent lasting power of attorneys executed by P in favour of EG's daughter, SB. So it was an application under Section 22 of the MCA to effectively determine the validity of the lasting power of attorneys. I just pause there because in Section 22, there is the power for the court to determine the validity of lasting power of attorneys. And it can do that on a couple of bases. It can do it on the question of whether the LPA is formally valid, so whether it complies with all the various formalities that are set out within the Act, so sort of the equivalent to Section 9 of the Wills Act, or the court can look at whether P lacked capacity at the time of execution. And a third basis is on the basis of undue pressure or fraud, which is probably, or certainly in my experience, a harder ground upon which to succeed. At the outset of the application, DG was not a party, and that was not something that was a surprise or should be a surprise, because as you've seen from the previous slide, DG was not an attorney under any of the LPAs and was only MMP's family member by virtue of marriage. So as a starting point, he didn't have an interest in the determination of the validity of the lasting power of attorneys. What was quite clear from the application and the judgment is that at the heart of the application in the Court of Protection was a dispute about a property. And that is a scenario that I'm sure many of you have in your current cases and have perhaps come across previously, where there are disputes about other assets that P might own or that others might own, and family members seek to bring those within the form of the Court of Protection to seek the court's adjudication on those. In terms of the property dispute, there was a property purchased by EG and DG some years ago, purchased in their joint names with a mortgage in their joint names. The issue was whether MMP had contributed to the purchase of that property, whether MMP and her deceased husband had contributed to the property. Because as a starting point, if someone contributes a large sum of money to a property, they may be able to argue that they have acquired a beneficial interest pursuant to a common intention constructive trust, either implicitly or explicitly. So IP and AP were of the firm view that their mother held a beneficial interest in this property. She had lived there with her husband who predeceased her, whereas EG and DG were saying, no, this is a property that we owned and we just let mum live there. The application proceeded to a dispute resolution hearing under Practice Direction 3B. When a case is allocated to that pathway, it will, save in exceptional circumstances, always proceed to a DRH at the local hub. That DRH was presided over by Deputy District Judge Chahal. That's not a hearing at which I was present. I wasn't instructed by that point. So what happened, I have to discern from the judgment and the order that she made. She said on the face of her order that the DRH was ineffective. And the order that the judge made was that, notwithstanding it being an ineffective hearing, that the same judge could hear any further applications in the case or any further DRH, but that she could not consider the final hearing in the event the application proceeded to one. Then the judge ordered that there was to be evidence filed by the parties on the property dispute. So the judge at the hearing invited the parties, or ordered the parties, to set out their case factually on the beneficial interest point. Perhaps the most important point for today's purposes was the injunction that the judge made at this DRH. It says in the judgment of Her Honour Judge Hilder that this injunction was made of the court's own motion, which essentially means that the judge wasn't invited to make it by the parties, but felt in the circumstances it was necessary to do that. And the order was essentially requiring EG, who was at that point a party, and DG, who wasn't a party. So pausing there, he wasn't present at the hearing and he wasn't represented. The order prevented the couple from dealing with the net proceeds of sale of the property because by that point it had been sold. On the face of it, therefore, District Judge Chahal restrained a capacitous couple from using what on the face of it was their own property, certainly which they held legal title to. And as a result of that injunction, the district judge added DG as a party to the application. Now, the basis for her adding him was simply because of his being covered by the injunction order that she made. Thereafter, I became involved in the matter and saw that order and was immediately very surprised by the content of it. And so an application was made by me and my legal team at Stevenson's on DG's behalf to set aside the injunction. That application was heard again by District Judge Chahal. That went to a contested hearing, at which point a written judgment was provided. And the outcome of that judgment was that District Judge Chahal set aside her original order. So the order that she made at the DRH, at which DG wasn't present, was set aside. She made an order in its place that made another injunction, so the second injunction order. And what she did there was order DG and EG not to deal with the proceeds of sale that they held in their possession up to the sum of £151,000. She directed further that the two of them were to provide statements setting out where they held their share of the proceeds of sale. So it's very much akin to an order that you might see in the civil court if you were dealing with a property dispute where there were concern about dissipation pending the trial of the matter, and a party might be ordered to not deal with the money in the interim. The judge's reasons for making this injunction in summary were these. She acknowledged or found that the Court of Protection has the power to make an injunction, and she was not wrong about that. As I'll go into shortly, the Court of Protection does have discrete power to make injunctions. She went on to say that the power to make that injunction extended to the scenario we had, which was to prevent capacitous individuals from dealing or not dealing with their own property. And the reason she felt that that was the right outcome was she said that it was surprising if the Court of Protection is powerless to protect P ahead of a final hearing where there is a dispute about her beneficial interest in the proceeds. Now, just pausing there, any final hearing in the Court of Protection would and should have never have dealt or made an inquiry into the issue about the beneficial interest for the reasons that I will come to. The second reason was that District Judge Chahal felt that the COP's responsibility was to preserve the status quo and to protect the vulnerable, even though the issue to be determined would ultimately be by a civil court. So what the judge was saying was that she recognised that ultimately determination of what the beneficial interest in the property is an issue for the county court or perhaps the business and property court. But the judge said that whilst that dispute is being litigated or determined, the Court of Protection can effectively step in to preserve that status quo and protect P. And she finally said that the court has the power to protect MMP's interest pending resolution by a civil court. So the obvious motivation, I think, from her remarks, which are set out in Hilder's judgment, was a desire to protect P, which is what, to some degree, the court is there for, but it can only do that within the remit of its defined jurisdiction within the Act. And what one might say when they look at this judgment is say that perhaps the learned judge fell into the trap of being overly protective of an incapacitous individual. So as a result of that written judgment, DG and EG then instructed me and Stevenson's to bring an appeal on their combined behalf. And the basis of the appeal was quite a simple one. It was to say that District Judge Chahal was wrong in law to make the injunction because the Court of Protection has no jurisdictional power to make that type of injunction in those circumstances. And if we were right about that, then it followed that the court then had no power to order EG and DG to say where they were holding the money. We also said that it was wrong of the judge to add DG as a party to the application, because given the injunction we say was made on a misguided premise, there was no other reason for him to be added as a party because he had no interest in the validity of the lasting power of attorneys. The appeal succeeded. As I say, it was heard by Her Honour Judge Hilder. And in short, the outcome was that the injunction was set aside, and the judge also agreed that the disclosure order should never have been made and that DG should never have been added as a party. I'm going to now deal with the key points that I think the judgment raises that are useful for those of you, particularly dealing with property and affairs litigation, not only contentiously, but also for those of you who might be acting as deputies as well. The first point, and I think this point is somewhat overlooked sometimes, is that it is abundantly clear, or should be abundantly clear, that the COP's jurisdiction to deal with litigation affecting P's estate is fairly limited. What one has to always remember is that the COP's power to do anything is to make a decision on P's behalf that they cannot make for themselves. That applies whether it's in the health jurisdiction or the property and affairs jurisdiction. And that's why the starting point or the gateway is always capacity. Because if P retains capacity on the particular decision, then the COP has no power. If P lacks capacity on the particular decision, then that gateway is opened. When any individual finds themselves in dispute with another person, whether that's about a property or about a will, for example, he does not have the ability to determine that dispute. Of course, they can settle the dispute, but determination of the interest is a matter for a civil court, so either the county court or the business and property court. And so Judge Hilder, at the beginning of her judgment, when she deals with her analysis, deals with the Supreme Court decisions of Aintree, which emphasises that the COP can only make decisions that P cannot make for themselves. And Judge Hilder said it's generally uncontentious that the COP cannot determine whether P has or does not have a beneficial interest in the property or its proceeds. My experience is sometimes that's not understood entirely, because sometimes I have seen applications where there are issues about P's property and what interest they might have. And then applications are made to the COP, asking the COP to determine those rights. By way of example, I recently dealt with an application for a deputy who had been brought in on the back of contentious proceedings about who should be a deputy and about the validity of the LPA. And having looked at the order, and of course we weren't involved in those proceedings, it became clear that during the course of that hearing that the judge had been invited to make findings about whether P's daughter had an interest in the property. And the court found that she did, and effectively made declarations under the Trusts of Land and Appointment of Trustees Act 1996 to effectively give away P's property, which was quite remarkable because the Court of Protection does not have the expertise, and I think Judge Hilder would be the first person to say this because she said this to me before in cases, that the Court of Protection is not equipped or does not have the expertise to make those determinations. Those are for business and property judges. So it's really a point that has to be driven home, that if there is a dispute about P's interest in the property in an estate, then the Court of Protection is not there to determine that. That's for a different jurisdiction. Where the COP does get involved with that is the question of whether somebody should be authorised to act on P's behalf to bring that litigation. So in this example, there was a dispute identified. The next step might have been to bring litigation within the county court. someone would need to do that on P's behalf. And for those of you who are well acquainted with REACC, if that person wants to bring that litigation on P's behalf and they want to have an indemnity for their costs of doing so, then they have to get the Court of Protection's authority to authorize them to bring those proceedings. And if they bring those proceedings and don't have that indemnity, then they aren't entitled to recover their costs. So Judge Hilder makes plain that where there might be disputes like this, what the court can do is authorize a deputy or make a discrete deputy order to authorize somebody to conduct that litigation on behalf of P. But that is subject to the procedural rules within the particular jurisdiction in which the claim is being dealt with. So the ultimate decision about who is a litigation friend in civil proceedings is one for a civil court. I haven't personally seen for a long time a position where a civil court has declined to appoint as a litigation friend someone already appointed by the COP, already authorised by the COP to conduct litigation. Conceivably, that would be open to a civil court, but in my experience, there need to be very good reason for doing that. But the starting point in the CPR Part 21 is that a deputy authorised by the COP to bring litigation is the first person who should be considered as a litigation friend. And I put in brackets there the FPR, so they're just the family procedure rules. So the appointment of litigation friend, it might be slightly different in that, but it's not a jurisdiction which I ever have practiced, I must say. So moving on to the second key issue that she deals with in her judgment is about DRHs. And the judgment's useful for this reason, because as far as I'm aware, it's probably the first decision where Judge Hilder has given some views about dispute resolution hearings. They are designed to bring the parties before a judge at a very early stage before significant costs and litigation are incurred. Each court has a different template order that they send out, in my experience, but usually it will be along the lines of, once the COP 5s have been sent back, is to say the parties are ordered to attend for a DRH. They must attend 1 hour before so they can have discussions, and the parties can only file a 2-page summary of their position and no further documents. So the idea is that you're not getting into the expensive exercise of drafting witness statements before the DRH. Now, of course, if you're the applicant, you will have drafted a COP 24 with your application anyway. But the idea is that the respondents won't have to go to that exercise. If obviously the DRH is unsuccessful, then directions will be given for that. But as Judge Hilder reminds in her judgment, she says that the purpose of the DRH is to enable the court to determine whether the case can be resolved and avoid unnecessary litigation. In the BPC, so the Business and Property Court, we have a similar style of hearing, which is usually called a DRH or something like an early neutral evaluation. We have this particularly in Inheritance Act claims where the temperature can rise very quickly. And like, sadly, COP litigation, there can be a huge amount of acrimony between family members. And the idea, again, is that you go before a judge and a judge will give you a without prejudice view and an open view so that your clients can hear it from a judge, which they generally, I think they find it quite helpful. So I'm in favour of DRHs. I think they can work very, very well as long as you prepare very well for them and use the time effectively. And the judge says it's the singular opportunity for the court to give its view on the likely outcome of the proceedings so that the parties can take a realistic view at any early stage of the merits of further litigation. Those of you who are dealing with contentious COP will see these all the time in deputy removal applications or deputy appointment applications. And they work very, very well I'd say that in most of my cases that go to a DRH, it ultimately settles at the DRH. But where I think this case is helpful is that some judges are reticent to give an open view about what they think will happen at a trial. And the judge here makes it clear that that's what the purpose of the hearing is. So judges at these hearings should be pushed to say what they think and how it's likely to pan out at a trial, because the idea is that the parties hear that, and having been reminded of the HOP rules and how one can depart from those, may reconsider any entrenched positions. The judge also said that at the hearing, it's incumbent on the parties in the court to identify the issues in the application. I think that's really important, because that focuses everybody's minds on what type of evidence you need to get going forward. So what I tend to do is just in the recital to any order, set down what I see the issues to be. Where I think Judge Hilder's comments are also really helpful is she talks about what an ineffective DRH is and what a successful DRH is, because you'll recall from the earlier slide that at the first DRH in the MMP case, that DDJ Chahal said that the DRH was ineffective, and that seemed to be a basis for her ordering a further DRH. And so just pausing there, the Judge Hilder said that a successful DRH is obviously where the parties come to an agreement. And of course, any agreement has to be approved by the court. So it has to be considered to be in P's best interest. I think I've only had one case ever where the parties have come to terms and the judge declined to approve it. But I think that was, well, I can't quite say what the reasons were, but ultimately, we did manage to get it approved in front of a different judge. But you can have an effective but an unsuccessful DRH. The DRH proceeds, but for various reasons, you don't come to an agreement. An ineffective DRH is where, for whatever reason, it actually doesn't proceed. And the reason Judge Hilder cites may be that one of the parties doesn't turn up. And that can happen quite a lot where you have individuals who are representing themselves. And just pausing there, I think my approach with this is sometimes you get litigants in person who will file a COP 5 as a sort of instinctive reaction to the application. And as time goes on, they'll retreat from that and realise that actually they don't want to object and they're not really interested anymore. And I've found that in the lead ups to hearings, they will then send an email to my solicitor and saying, I don't want to get involved in this anymore. If that happens, then I think it's really useful to either do a consent order before, if there's time, but just get them to say in writing that they don't want to object anymore. So you can show that to the judge, because then what it means is that the judge may then be prepared to deal with it summarily with a final order. Whereas if you don't have that, the judge might say, well, they might not be here for various reasons. And what Judge Hilder says here is that once the DRH is effective, even if it's unsuccessful, that judge must not engage with that case in any substantial way going forward. And I think that's overlooked quite a lot, because I have seen orders where a judge has dealt with it at a DRH and then they've dealt with the final hearing as well. And so, and that's perhaps in smaller court centres where there might just not be enough COP judges. So what I tend to do with the order after a DRH is say on it that the district judge, whomever, should not hear any further matters, any further applications in this case, because it just makes it clear to the court staff when they list it that it shouldn't be listed in front of that same judge. Hilder also dealt with, well, what happens if you have an ineffective DRH? Can you ask the judge in those circumstances just to make a final order? And that's where she says that there may be a whole host of reasons why somebody might not turn up. And whilst that's frustrating, the wording of the practice direction is such that the court should, notwithstanding that non-attendance, still go on to make case management decisions, case management directions with a view to a trial. So I think unless you have something definitive from the person on the other side who's not turning up saying, I don't want to object to this anymore, the reality is if the DRH doesn't proceed because of non-attendance, you then need to have case management directions to a final hearing. And Judge Hilder, that perhaps the better way of dealing with that is a cost consideration. So she's effectively saying then you can seek the wasted costs against that individual. The difficulty I have with that is my experience is it's quite difficult for COP judges to make orders against litigants in person in the COP. And I'm sure many of you have had that similar experience where it can be quite frustrating, where sometimes it seems that litigants in person can be given quite a bit of latitude, and that can lead to wasted hearings and the incurrence of huge amounts of costs, which ultimately P is going to be paying. But certainly, if someone isn't attending for hearings, then I'd certainly be trying to seek an order against them for costs. And I think this is also a useful point, because I've seen quite a lot where judges will have a DRH, but they run out of time, or the parties say, thanks very much, but we need to have a think about this. You know, we'll continue our discussions outside. And then the judges said, well, I'll relist this for a second DRH. Hilder makes clear you're not supposed to do that. She says there should be one DRH if it is effective but unsuccessful, then you don't list a second DRH. You do what the practice direction is, which is set down directions and proceed to a final hearing. And she says in her judgment that the COP is not a mediation service. Of course, if you don't reach an agreement at the DRH, there is absolutely nothing to stop you engaging with the other side to try and compromise, and parties should be doing that. There's also the option of mediation as well in COP cases, which I think is underused by parties. It can be a very, very valuable tool in getting hostile, family members that are hostile to each other, talking about things. So, but the use of mediation is certainly increasing within the COP, but certainly not to the extent of in my probate practice, where in almost every single case we have a mediation. So those are just some comments that she makes about the DRH that I think are really helpful, because until now, there's not been any guidance about what you should be doing if it doesn't go ahead, or if you sort of half get there, should you be having another DRH? So it's quite a useful authority to have in your back pocket in case you are at a DRH and the judge thinks, well, I'll just list another one. You should be directing that individual to this case. So the final point is about the COP's power to make injunctions. And for the appeal, I was certainly not able to find any previous authority that dealt with the COP's power to make an injunction in the property and affairs jurisdiction. A matter of days before this appeal was heard, I think the day before the Court of Appeal decision of Re was handed down, and I just happened to see it posted on Twitter. And that deals with injunctions in the facts of that case in the health and welfare context. So it's certainly useful to go and have a read of that. But what was agreed is that the COP does have a power to make an injunction, and that's set out in section 47. So it makes it clear that the COP can exercise the same powers as the High Court. The High Court undoubtedly has the right to make an injunction. But the key bit of section 47, and this is where Judge Chahal went wrong, is that it has to be in connection with the COP's jurisdiction. And as I've said before, the COP's jurisdiction is to make a decision on behalf of P that they cannot make themselves. So I moved to Re, and I would, if you've not read it, I would certainly go and give that a read at some point, because it's really useful, I think, particularly for those of you who practice in health and welfare matters. It's a while, I read this just before the appeal, but the facts, I think it was Hayden who might have dealt with it, but effectively there was a best interest decision under section 16 that P should move to a particular placement. And I think family members, or a family member was trying to obstruct that by sort of harassing care home staff, turning up at the care home, just trying to make it as difficult as possible in a deliberate attempt to frustrate the order that the COP had made. And so the judge made an injunction at first instance. That was then appealed, and the Court of Appeal considered this issue about what is the COP's power to make the injunction. And what it says, in a nutshell, it's quite a long judgment, but in its simplest form, it says that there is the power to make the injunction, but that injunction has to be used to give effect to the COP's best interest decision. And that's, I think, a really useful way of looking at it. So the COP makes a best interest decision, so that P moves to a certain place, or P has contact or doesn't have contact with a particular person. And an injunction is used to enforce that order or to stop somebody frustrating that order. So with the contact aspect, you might say that there's then an injunction stopping X from having contact with P. The test that you need to have a think about if you are drafting an application, this is the sort of framework that you need to have a look at. Is it just inconvenient to make the injunction? And that's broadly the test that we have a look at in the civil jurisdiction. The Court of Appeal case and the EG case doesn't really go into the procedure so much of an injunction. And I would personally follow the kind of civil style approach to an injunction, but that's a talk for another day. But when you're thinking, well, what does just inconvenient actually mean? Court of Appeal said that there are two questions you need to think about. The first is there an interest of the claimant which merits protection? And is there a legal or equitable principle which justifies exercising the power to order the defendant to do or not do something? And where you've got the COP making a best interest decision that P shouldn't have contact with a family member, they clearly have an interest that requires protection. And the example that the Court of Appeal cite in the property and affairs context is about the transfer of P's assets. So once you have a deputy who is discharged and you have the usual order saying the discharged deputy must hand over all assets. If you get someone who refuses to comply with that, the court could remake that order with a penal notice, which then makes it into an injunction. And if they fail to comply with that, then they are in contempt of court. And you could then make an application for that. And that has for committal, which has up to 2 years imprisonment in the sort of worst examples. So in going back to our case, Judge Hilder gave various reasons for why the judge at first instance was wrong to make the injunction. She said that in our case, that what the court's being asked to determine is about the validity of the LPAs. So that's the decision that a judge is going to determine whether they are valid or not under Section 22. So that's not a Section 16 best interest decision. And she goes on to say that an injunction is just not required to enable that decision on validity to be put into practice. And she said that the injunction was not ancillary to preventing frustration of the court's validity decision. So in another way, the court decides whether they're valid or not, and the injunction isn't necessary to stop somebody frustrating that decision, because there's no realistic way how they could do that. What she goes on to say is the only decision that court could make in this kind of scenario is I could authorize somebody to conduct the litigation on MMP's behalf. So that's essentially a best interest decision under Section 16. But then the judge goes on to say, well, an injunction is just not necessary to give effect to that order. Whoever is authorised to bring the litigation doesn't need an injunction to enable them to effectively conduct that litigation on P's behalf. So what she said is that the injunction that was made is actually ancillary to the civil court's power to determine the claim. And that's obviously right, because in a civil court, if there is in a scenario like this, if there is an alleged beneficial interest in a property, you can bring an application for a proprietary injunction. So if you get wind that someone's going to sell a property, they've not agreed to leave it in an independent solicitor's account pending the dispute, you might in those circumstances bring a proprietary injunction to restrain them from dealing with it. And the civil court does that to protect the potential right that the claimant has in that money. So the injunction is ancillary to the court's ability to determine the beneficial interest, but that's a power that only a civil court has. The Court of Protection quite clearly doesn't have that. So what Judge Chahal was saying is saying the civil court's going to determine it, but I'm going to make an interim order, even though I recognise I can't make a final order. So it was obviously a wrong decision. So where does that leave us in sort of day-to-day practice? I think the Court of Appeal decision is really helpful. I think Hilder's decision fortifies it and makes it clear that it applies in a P&A context. I think realistically, the circumstances in which you need to be seeking injunction in the P&A context are probably quite rare. And I'd be interested if anyone wants to say on the chat if they've ever had cause to do it. Because I haven't yet. But in terms of the principles to take away from this case, the COP does have the power to make an injunction. That applies to both sides of the jurisdiction, but it's a discrete jurisdiction and a power. And so if you're thinking, can I make this type of application? You've got to be thinking, is this injunction necessary to enable the court's best interest decision to be put into practice? Another way, if I don't get this injunction, is somebody else going to frustrate the COP's best interest decision? And I think that's quite a useful way of looking at it. So I tried to have a think about where these sort of examples might arise, because I do often get asked by deputies, P's parents keep stealing P's mail and things like that. And so, and obviously you don't want to be wading with injunctions in a family context, but it might, give some of you a bit of confidence that if things get really, really bad, and it really is causing an impasse and frustrating the administration of P's estate, there is this application that you might think about making, although of course I'd say, run the circumstances past, obviously I'm going to say me, but any other counsel if you wish to. But obviously the obvious example is former deputy not handing over the property for whatever reason. And I also thought, you might have a decision of the court that it's in the best interest of the deputy to purchase this particular house for P. And I've had circumstances before where maybe an estranged family member doesn't like that idea because, unfortunately, some people are money motivated and think, I don't want £1 million of P's personal injury money being used to buy a house that my ex-husband and his new wife's going to live in with P. And so then they can deliberately do things to try and prevent that from going ahead. And so you might have an example where the individual started, calling up the estate agents to try and frustrate the sale, or go around to houses, to try and get involved in the viewings, things like that. And I thought maybe that might be a circumstance if it got really quite bad, where you could maybe think about an injunction order. But as I'd say, injunctions are for exceptional circumstances, and the circumstances do have to be quite compelling because they are very draconian orders. And if they are breached, then you can bring committal proceedings. So I wouldn't rush to make an injunction, always try and find another way, but potentially it's there. So if you as a deputy, for instance, find yourself in a position where somebody is trying to do something to frustrate you, putting into practice and into effect the court's best interest decision, that's where you just might think about an injunction, whether that's something that might be of assistance to you and to P. So that's it from me. My email address is on the slide. I'll send this out to you. I've just noticed that there is a question there. What I'll do is I will get that person's email address and I'll email it to you, the answer. But as I say, as always, my virtual door is always open. So if anybody has any questions after the talk and wants to run those past me, then do feel free. But that leaves me just to say thank you very much for attending. And I will see you on the next occasion. Thanks very much.